afternoon. We are hearing the matter of TML3, alleged delinquent child, Doggett County case number 12JD102. Present in the courtroom this afternoon is TML3, correct? Represented by attorneys Friedman, DeVan, and Walton.
That's correct, John.
Also, the legal guardians, Jack and Carol Nolan. Present for the state is Doggett County Prosecutor David Joyce, Assistant County Prosecutor Nick Burling. Representing the state also is Chardon Police Chief McKenna. We also have Michelle Schroeder from the court's Chief of Probation. The purpose of today's hearing is a hearing on the issue of TML3's competency under Ohio Revised Code Chapter 2152. The court has provided, both for the media and family members, a explanation of what this hearing is about. I do want to apologize for the half-hour delay, but invariably in these proceedings, there are last-minute issues that come up with the lawyers in the court that need to be addressed, and so we apologize, but then we did the best we could to get started in a timely manner. Let me go through the purposes then of what is competency. Under Revised Code Section 2152.51A1, competency for purposes of this hearing is statutorily defined as a child's ability to understand the nature and objectives of a proceeding against the child and to assist in the child's defense. The evidentiary standard to be applied by this court is the preponderance of evidence standard. The court has previously provided and filed a notice of the evaluation timeline that spells out the time process from when the initial order for evaluation was filed on March 21st, 2012 through today's date of the competency hearing, which will be part of the record. At this point, the court would like to confirm, first of all, that each of the parties has received a copy of Dr. Resnick's competency assessment report. Attorney Freeman, have you received a copy?
We have, Your Honor, all counsel.
Thank you. Mr. and Mrs. Nolan, you have received a copy? Prosecutor Joyce, you have received a copy?
That's correct, Your Honor.
The court will represent that the guardian ad litem also was provided with a copy. The court is aware that there is a joint stipulation that has been filed on this date, signed by attorneys DeVan and Friedman on behalf of TML3, on behalf of Prosecutor Joyce, on behalf of the state. The court has provided a copy of this joint stipulation to our court reporter, Bev Modick, and it will become part of the transcript of these proceedings. Prosecutor Burling, do you want to read the stipulation for the record?
Yes, Your Honor, thank you. The joint stipulation reads that the alleged delinquent child of the state of Ohio by counsel hereby inform the honorable court that the parties stipulate to the following: that TML III is under the age of 18, the identity of TML III, and that the delinquent acts alleged in the complaint did occur in Doggett County. Therefore, this honorable court has jurisdiction to hear the case for purposes of the competency hearing and be binding over here.
Thank you. Can the counsel also stipulate that TML3's age is 17 at this time?
On behalf of TML3, yes, Your Honor.
Prosecutor Joyce?
Yes, sir.
All right. At this time, since the court has subpoenaed Dr. Resnick as the court's witness, the court will call Dr. Philip Resnick to the stand. Meeting fine. Dr. Resnick, please. And for the record, everybody at the council table does have a copy of Dr. Resnick's report of April 3, 2012. Is that correct?
We do, Your Honor, on behalf of TML3. That's correct, Your Honor.
Mr. Nolan, you also have one. The court will note that this has been marked as Court Exhibit 1 for purposes of these proceedings, and that this Court Exhibit 1 will remain under seal with the court. Dr. Resnick, would you come on here, please? right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth regarding any testimony you give in these proceedings, and so say I do?
I do.
Please be seated. And would you state and spell your name for the record, please?
My name is Philip Resnick, R-E-S-N-I-C-K.
And you are employed by?
Case Western Reserve University.
Dr. Resnick, you have been retained by the court in this matter to address the issue of competency pursuant to Chapter 2152 of the Revised Code, is that correct?
That is correct.
And in that process, you have provided a report of which I will ask the court reporter to hand to you, which has been marked as Court Exhibit 1 for these proceedings. You take a moment to review that.
Yes,
Is that a true and accurate copy of the report that you submitted to the court?
it is.
If I could direct your attention to the curriculum vitae that is attached.
Yes,
It's my understanding that counsel has agreed to stipulate to the curriculum vitae, is that right, Mr.
That is correct.
Prosecutor Joyce?
That's correct.
So without going page by page through your curriculum vitae, can you summarize, though, for the court, your qualifications that would give rise to you being qualified to do the competency evaluation in this matter?
yes, I have an undergraduate degree in psychology from Case Western Reserve University, a medical degree from the same university graduating in 1963, and a one-year internship in El Paso, Texas, 3 years of psychiatry residency at University Hospitals of Cleveland.
And you are currently, what titles do you hold at the School of Medicine at Case Western Reserve University?
Yes, I'm professor of psychiatry and director of the Division of Forensic Psychiatry. And I have been on the faculty there for more than 40 years.
Does either counsel have any questions as to qualifications of the witness at this time?
I did not at this time.
Dr. Resnick, have you testified on issues involving competency of individuals in other courts?
Yes,
And can you just list a few of those?
testifying on competency issues. One of my roles is director of the court psychiatric clinic of Chardon County. And in that role, I have testified numerous times on competence to stand trial. I've also testified in other courts around the state and around the country.
And the court, in its request that you undertake this competency matter, did provide you with a copy of Chapter 2152 Revised Code, is that correct?
Yes, that was specific law regarding juvenile competence.
And you did study that before you undertook the evaluation by CNO?
Yes, I did.
Can you state to the court what was the evaluation process that you employed in this matter?
Yes, I began by gathering extensive records which were provided by the court regarding any prior treatment of the defendant in this case. And then I spoke with his attorneys by phone and his guardian ad litem. And then I performed a personal interview with Mr. Lane for 6.25 hours on April 2nd, 2012.
And as a result, did you feel you got sufficient information to form an opinion within reasonable medical certainty as to TML3's competency for purposes of these proceedings?
Yes, I felt I had sufficient data.
Did you go into specific questions with him as to the legal process that we are currently in?
Yes, I reviewed his knowledge of both some juvenile procedure and adult procedure. I reviewed with him his understanding of what the charges were, what the potential penalty was, the adversarial nature of the court procedure, and so I
TML3, in his opinion, understand and appreciate the charges and potential penalties that he is facing?
Yes, he did.
Did he exhibit a good understanding of the adversarial process that we're into right now?
Yes, he did.
Did he exhibit a good understanding of the purpose of his defense attorneys and what their duties are in this case?
Yes, in fact, his words were, the defense attorneys were to get him as little time as possible, and the role of the prosecutor was to get him as much jail time as possible.
Was TML3 able to communicate clearly with you, and do you have any doubt of his ability to communicate clearly with his attorneys in defense of this matter?
Yes, TML spent 6.25 hours. During that time, he did not fatigue. He remained articulate. He remained attentive, and he was able to convey his whereabouts and circumstances at the time of the crime. I saw no reason that would interfere with his ability to communicate with counsel.
Is it your reasonable medical certainty, your opinion that he currently suffers from any mental illness, intellectual disability, or developmental disability that would impair his ability to understand the nature and objectives of these juvenile proceedings against him, and his ability to assist his attorneys in defense of these proceedings?
It's my opinion he does suffer from a mental disease, but that mental disease does not currently interfere with the functions necessary for his competency schedule.
Is it within reasonable medical certainty, your professional opinion, that TML3 currently is able to understand the nature and objective of the proceedings against him?
Yes.
Is it your professional opinion within reasonable medical certainty that TML3 is able to assist the defense attorneys in the defense of these juvenile proceedings?
Yes, that is my opinion.
And I'll turn it over to counsel. We will start with TML's attorney.
Thank you, Your Honor.
Thank you.
And if you don't mind, I don't know your protocol. If you don't mind, I've always felt more comfortable saying that.
You may stand up. Would you like the, you can put that,
That would be even better. Thank you.
that would be my, please.
Good afternoon, Dr. Resnick.
Good afternoon.
And just for the record, I am Ian Friedman. You and I know each other. If I ask any questions that you don't understand or if you need additional clarification, I would ask you just to ask me to repeat the question. All right, fair? I just want to elaborate on one point. You have stated that as part of the evaluation process, you spoke to TML's attorneys, and I'm going to call him TJ if it pleases the court. TJ, thank you. So I'm going to refer to TML3 as TJ from here forward. Okay. And you indicated that you spoke to his attorneys. I want to clarify those were prior attorneys, not myself, Mr. Dan, or Ms. Walton. Correct?
That's correct. I actually spoke to 2 of his 3 prior attorneys.
Now, you had stated a moment ago that as part of this competency evaluation process, you needed extended detail, and that was hence the purpose of the 6.25-hour interview. Therefore, would it be fair of me to say that it would be, you felt it insufficient to simply ask TJ, do you understand the process, do you understand the roles of the attorneys, and so forth? You needed to get a full history and a comprehensive picture of where TJ was at the time of your interview mentally, correct?
Yes.
All right. So, in line with that question, I would like to just kind of get some clarification on your report that you issued, and that has been marked as Court Exhibit A.
One.
One, sorry. And if you need to refer to it, please do. You spoke to TJ originally on April 2nd. That was the date of the 6-hour, 15-minute interview, and that was at the Port of Chicago Juvenile Detention Center, correct?
Correct.
And you were there also with another gentleman doing his psychiatric fellowship by the name of Joseph Blackens, correct?
Yes.
All right. And so the both of you were there, and you had talked about some of the steps that you've taken, speaking to the attorneys, looking at prior treatment records and so forth, speaking to the GAL, and the GAL in this case, as you recall, was Sarah Hefner, correct? And some of the records also that you looked at in this case to make this full determination of competency and to get a comprehensive picture of TJ were the police summary reports, correct?
Yes.
And in addition to the interview and speaking to the guardian and the attorneys and relatives as well, correct? You also looked at the DVD recordings of prior court appearances where TJ appeared both February 28th and March 6th of 2012, correct?
Yes.
Okay. So all of this helped you to craft the report, which is the court exhibit that we just referenced. And now I'm going to ask for some clarification on certain points of your report. And I did have 10 questions. The court did a very good job in asking, so I'm left with 8. All right. First question I ask is, in your report under the section of educational history, you wrote that TJ remembered having migraine headaches for as far back as he could remember. It was reported to you, as you memorialized in your report, that these headaches caused him to miss a significant number of days from school, going all the way back to elementary school. And my question to you is, what is the significance of this information within the context of the competency evaluation? Why did you feel it necessary to touch on it and memorialize it? Objection.
Well, first of all, in doing the competence report, I gave a broad background of medical history, psychiatric history, education history. So not every sentence in the report is directly relevant to the competency stand trial question. So this information was garnered really as part of the school and medical background.
Okay. All right. Would that also hold true then, I don't know, for the portion of your report where you had indicated that TJ had been struggling with depression, sometimes lasting as long as months? Objection.
Yeah, well, the psychiatric history is, of course, particularly relevant in terms of understanding TJ's current mental status and the likelihood that any interference of psychiatric symptoms would impair his ability to either cooperate with counsel or attend to a trial. So the psychiatric history was more directly relevant.
Okay, so this symptomology under the psychiatric history you're saying is necessary for the determinant of competency in this proceeding. That's what I'm hearing you say.
Yes.
Also then, under the provision of psychiatric history, you had indicated that there was a description of altered mental states in which TJ was, and I believe you were preoccupied, staring, and quote, mentally not there. And my question to you is this symptomology also necessary for determining competency in this proceeding? Objection. If. I'm sorry, that's my question. Second question, last. Thank you.
Yes. In other words, since he described some periods where he was in an altered mental state, where he was, for example, not attending to schoolwork, I explored that to see if that would interfere with his ability to attend to a trial.
A few more questions. And I guess the obviously the portion of diagnostic impression is critical in your task, determining whether or not TJ is competent to stand trial, correct?
Yes, the diagnosis summarizes what mental illnesses are present, and is certainly relevant to his competence.
Okay. So as you stated in your diagnostic impression, you determined that TJ suffered from psychosis not otherwise specified, correct?
That's correct.
And if you could, please explain for me kind of this determination as it applies to this competency proceeding. I don't need to get into the DSM and so forth in general, unless you need to for this particular, but I want to know how this relates to this Objection.
Before you do that, Mr. Stanley, this hearing is dealing with his competency. It's not an answer. It will affect your opinion as to his current mental status and his current ability based on his mental status to understand and assist his attorneys. And then you're free to answer. But as you know from my original instruction, there was limitations placed on this report as to not expanding beyond the purposes of these proceedings. You understand?
I did think.
And Your Honor, that's why I want to limit it simply to these proceedings here, and I was gonna, I
So
apologize.
I
for cutting
would
out.
grant the objection to accept the witness is going to go beyond those parameters. Arguments
So again, within the parameters of this competency evaluation.
Yes, psychosis not otherwise specified is a diagnostic category, which means that someone is psychotic. That is, they are suffering symptoms which cause them to be out of touch with reality, such as delusions or hallucinations. And if a more clear, specific diagnosis is made, such as schizophrenia or bipolar disease, one does not use the diagnosis psychosis not otherwise specified. So it's a more general diagnosis. And in this case, that was the diagnosis that I thought was most fitting. And again, the elements that made up that diagnosis, I wanted to look at each symptom as to whether it would or would not interfere with his competency trial.
Well, you did, I appreciate that answer. You did note that you found symptomology suggestive of schizophrenia, correct? Objection? Thank you. With regard to the competency evaluation here, was it important to look at other symptomology in this case?
Yes, in other words, the symptoms which led to the diagnosis of psychosis not otherwise specified, I wanted to look at each of those symptoms and see to what extent they did or did not interfere with his competency trial.
And did you make any determination of any other symptomology that formed your determination of psychosis not otherwise specified?
Objection, Your Honor. It's already stated that he's on.
I'm allowed to test the
I appreciate that, but you're not allowed to testify, and you're asking the doctor to have read things before he said that he was competent. This has no effect on his competence.
And why don't we just knock out all 4 pages of it and just simply say I'm the doctor? Here's my
I want the
finding.
court reporter to reread the question.
Did you make any determination of any other symptomology that formed your determination of psychosis not otherwise specified?
And I'll withdraw the question and rephrase it. What was the symptomology that led you to your finding of psychosis not otherwise specified?
Yes, the specific symptoms were emotional flattening or blunting of his emotions, his withdrawal from other people.
Can I stop you? And just right, can you please describe what flattening is?
Yes, most people have a range of emotions. They can be happy and smiling, they can be tearful and sad. And some people with a mental illness have a narrowing of those emotions where they don't have a full range of emotion. And that's called emotional blunting or flattening of emotions.
Okay, thank you. If you want to go on to the other symptomology.
The other symptoms that I identified were withdrawal from other people, auditory hallucinations.
Please explain auditory hallucinations more. Objection.
Sustain, you need to answer this question in the context of how they impact the competency of TML. Because no, I'm asking you to that area. Do you have a specific impact on your opinion as to his competency for these proceedings?
Yes, what I would say is that there is a history of it. He reported that he was not currently having auditory hallucinations. So, in that sense, that particular symptom is not concerning regarding competency unless they were current, but they were last symptom is relevant, and that is some involuntary fantasies which intruded themselves on his mind, and those I did explore in detail because I was concerned that they would cause a level of preoccupation where he could not attend to the trial. But in discussing this with him in detail and considering his ability to attend to my long interview, my conclusion was that this particular symptom did not prevent him from being on the test.
With regard to the last two, the auditory hallucinations and involuntary fantasies, are you able, or on the date of your interview, at the time of your report, are you able to state, let me back up, both the auditory hallucinations and the involuntary fantasies would be unwanted, correct?
Yes, they would not be under his control.
They would not be under his control. So, since the time of your report, are you able to say whether or not TJ has suffered from additional hallucinations or fantasies, as you originally discussed?
Objection.
Your Honor, the language, if I may.
But he's testified that he's met with him one time. We're asking him.
And because the language, Your Honor, defines the child's ability to understand the nature and objectives of the proceeding against the child to assist in the child's defense. Nothing about it talks about today and yesterday. It talks about the proceeding. This proceeding is going to be going on for a while. This is the doctor that was called, and these are the questions I'm asking for the determination of this proceeding.
And if in fact, Your Honor, in the future, evidence becomes an issue when he tested at that time, we're asking him to make a conclusion as to what his effect was, or whether his diagnosis was that he's now expounded upon when, on one day, April 2nd.
The court's going to note that no objections to Dr. Resnick's report has been filed, nor has there been a motion for a second or additional competency opinion. So based on that, no objection to sustained expression.
Thank you. And I just have two last questions and three. The term malingering. You agree with me if I may give the definition? Actually, I'll ask you to give the definition of malingering, please.
Objection.
Malingering of psychiatric symptoms would be where a person pretends to have symptoms or exaggerates their symptoms that they don't genuinely have.
And what, if anything, did you do during this process to determine whether or not there was any malingering at TJ Lane?
Objection.
I questioned Mr. Lane in detail about his psychiatric symptoms to clarify whether they were consistent with genuine symptoms or they were suspicious or malingering symptoms.
Did you make a determination based upon your study?
Yes.
And that was?
I did not see
Objection.
I did not see evidence that TJ was malingering psychiatry.
Was it important for you, Dr. Resnick, during this competency process to look into whether or not TJ should be medicated or not as a result of your determined symptomology?
Objection.
Finally, in your opinion, Dr. Resnick, toward the end of your report, you stated it is your opinion, to a reasonable degree of medical certainty, that TJ has a psychiatric illness of psychotic proportions. That's the opinion to which you signed on, correct?
Objection.
That's all I'm asking.
Sustained.
Nothing.
Prosecutor Joyce.
Thank you. I noticed your report under the mental status examination. You say that after your 6.5 hours of discussing this matter, the TML agreed that his thoughts were clear, logical, and coherent. Is that correct?
Yes.
He described his mood as calm,
Yes.
and he reported no delusional ideas such as paranoia or grandiosity. Is that correct?
That's correct.
When you talked before about emotional planning, tell me what you would call an effect. Correct? Some people have different affects.
Right. His affect was narrow and flat.
And people can go through life perfectly blunt and half-act and be productive since he's not any mental issues, is that correct?
Objection, Your Honor. The people going through life versus the competency exam of T.J. Lane.
I believe
Two different
there's
things.
a foundation.
Thank you.
Thank you. Well, I'll go to each question, and I'll turn the mic over to
Gentlemen, proceed, please.
Thank you, Aaron. Go ahead. Question.
Yes. Yes, people can be employed as productive citizens despite some narrowing of their emotional tone.
Now, on the second, when you saw this young man, had he been with his attorneys prior to that?
Yes, he has spent a good number of hours with his former secretary.
So the fact that he had been with his attorneys prior to that, and he is now explaining to you these auditory hallucinations he may have, when you reviewed all the other prior records that you reviewed prior to your interview with him, 6.5 hours, did any time, any of those records indicate that there was such a thing?
No, but he actually had not been treated by a psychiatrist where.
I appreciate that, and the question specifically was, anywhere in all those records prior to the day you met with him on Thursday, was there any indication that he suffered from these things?
No hallucinations were reported.
Great. In your findings then, for this courtroom, that he is competent, he knows the role of his defense counsel, and they're trying to get him minimum amount of time, and that I'm allegedly trying to get him a maximum amount of time, and the judge is here to sort of keep order and make sure everything works.
Yes.
Thank you. I have no further questions, Your Honor.
The court has a few. First of all, just to make it clear, when you mentioned that the attorneys you guys spoke with TML, and they were his attorneys at the time you spoke with them, correct?
Yes, they were.
Second, it is your opinion that TML's current mental status does not impair his ability to understand the nature and the objectives of these proceedings and Third, you were not asked by the court to conduct a full psychiatric examination of TML. Is that correct? It was competency that you were retained, correct?
Yes, in other words, it was an examination which was focused on that question.
Right. You did a lot of background because you had to be able to reach that conclusion, but the focus that you were retained was to address this competency under the revised code, correct?
Yes.
And so you were not retained by the court to give an opinion as to issues of mental culpability or legal sanity of TML-3, is that correct?
That's correct.
I have no other questions. Are there any questions based on the court's questions?
No, Your Honor, on behalf of T.J. Lane.
And on behalf of the state of Ohio, Your Honor.
All right, then, Dr. Resnick, you will agree this is a true and accurate copy of your report and curriculum vitae that we've marked as Court Exhibit 1?
Yes.
Do any of the lawyers have any objections to the admission? And you were instrumental in the preparation of this document, correct?
Yes.
And it reflects your work and your opinions as a professional. Psychiatrist and forensic psychiatrist, is that correct?
Yes.
Any objections to the admission of Court Exhibit 1 to the record?
No, Your Honor.
Prosecutor Jordan.
No, Your Honor.
Mr. and Mrs. Mellon. All right, then the court will admit Court Exhibit 1 into the records of this court. Are there any other questions for Dr. Resnick? If not, I'm going to release Dr. Resnick.
No, Your Honor.
No, Your Honor.
Thank you, Dr. Resnick, for your testimony. Is there any other information that the prosecutor would like to present to the court with respect to the issue of competency?
No, Your Honor, yes, the court accepts the findings of Dr. Resnick as they were prepared in his report to the court.
Mr. Friedman, is there any other information that you would like to provide to the court with respect to the issue of competency?
No, Your Honor. Based upon the report, with the addition of the testimony here today, we would also stipulate to the competency of T.J. Lane, reserving the right to raise that issue at a later date if need be.
All right, thank you. Based on that stipulation and the testimony presented, the court provides the following facts and opinion Dr. Philip Resnick is qualified to perform the competency evaluations of TML3 per revised code section 2152-54. The evaluation process conducted by Dr. Resnick complied with revised code section 2152.55. Dr. Resnick's competency assessment report concerning TML3 complies with revised code section 2152.56. Based on Dr. Philip Resnick's competency assessment report, which has been admitted into evidence without objection, based on TML's age of 17 years plus, based on the lack of any evidence of any current manifestation of a mental illness, intellectual disability, or developmental disability that impairs TML3's ability to understand the nature and objectives of these proceedings, these juvenile proceedings against him, and his ability to assist his attorneys in his defense in these juvenile proceedings, based on the court's observations of TML3 and his conduct and demeanor in the courtroom during the several proceedings that we've had in this matter, and based on the stipulation the court just heard from Attorney Friedman on behalf of TML3, this court determines by a preponderance of evidence in the record that TML3 is able to understand the nature and objectives of these juvenile proceedings against him. He is able to assist his attorneys in his defense in these juvenile proceedings. As such, TML3 is competent for purposes of these juvenile proceedings as that term is defined in revised code section 2152.51A1. This ruling applies only to the determination as to whether TML3 is competent for purposes of these juvenile proceedings and shall not be used or applicable for any other purpose but these proceedings. Having determined that TML3 is competent for purposes of these juvenile proceedings, pursuant to revised code section 2152.59A, this court shall proceed with these delinquency proceedings. The next scheduled hearing is the probable cause bind-over hearing, which has been continued and will be conducted on May 24th at 9 a.m. Again, the probable cause bind-over hearing will be conducted on Thursday, May 24th at 9 a.m. Is there any further business to come before the court? Prosecutor Joyce.
Nothing on behalf of the state of Ohio, Mayor.
Mr. Friedman.
Nothing on behalf of Teacher Line. Thank you, Your Honor.
Mr. and Mrs. Nolan. All right, everybody will remain in place. Counsel, first of all, TML and his lawyers may leave, and I believe they're going to have an opportunity to talk to their client. The court appreciates everyone's cooperation here today. I will leave it to our... Yes. You may follow him. I will leave it to Magistrate Lubecki to excuse everyone else. This matter is adjourned. Thank you very much.
Your Honor.